You're listening to the Lumina podcast by Ad Valorem, where we shine a light on tax, business strategy and personal wealth.
From running a business to planning your future, we bring real-world insight to help you stay ahead.
Let's get into today's episode. Welcome back to the Lumina podcast, where we unpack complex issues across tax, compliance and advisory work.
And today we're taking a deep dive into the world of R&D Tax Relief, because 2024 brought a wave of first-tier tribunal decisions that have shifted the landscape.
Joining us is our Head of R&D, Suzanne Clements, who's been analysing these rulings in detail. Suzanne, great to have you here. Can you give us a quick overview of why these cases matter so much?
Yes, well, when something gets to the first-tier tribunal, obviously there's a dispute between two parties as to how the legislation should be interpreted. So the judge then makes a ruling, and often a lot of detail comes out in those cases as to the judge's thought processes about this. So although at that level, at first tier, cases don't set a legal precedent, it's still a good insight into how a tribunal is likely to view something in particular.
So let's start with Get On Board. This was a win for the taxpayer, and there seems to be a number of them in recent cases, which is great. What did the tribunal highlight about competent professionals and the importance of evidence?
Well, this was a software case. It was centred on a project to develop an automated AI system for Know Your Client and risk and credit analysis. HMRC had rejected that claim, saying it was routine work that they were doing that was readily deducible by a competent professional. Get On Board had produced mountains of evidence that no such automated systems existed. There was an overarching need for one, and the question was, if there was such an overarching, compelling need, then why hadn't somebody else done it already if it was so routine? In this case, HMRC got egg on their faces. The caseworker that they put up at the tribunal to speak, he was a recent recruit. This was the first time he'd dealt with a software claim. There'd been no proper interaction with all of that detailed technological explanation provided by the company. And HMRC didn't come forward with any technological evidence of their own to support their own view. So the tribunal said there comes a point where there's a shifting of the evidential burden. So at some point, the company is entitled to say to HMRC, we've given you all of this evidence to show the advance that we were seeking, the technological uncertainties we faced. You need to explain now why you disagree that with what we say this shows, and explain why this is routine in the face of all of that. So this case really brought out was the importance of having a really knowledgeable, competent professional who's able to explain the technology and be convincing and articulate, show that he knows what he's talking about. The CEO of Get On Board, Edward Cahill, impressed the judge. So the case showed basically that if you've got that competent professional there who clearly understands the work, he's experienced, articulate, knowledgeable, he can convince a tribunal even without formal qualifications. And obviously in a lot of cases, software professionals don't have formal qualifications. They've grown up in that industry. So yes, it was very interesting.
Very interesting. I know on a number of those cases, the historic challenge on many inquiries are always competent professional. And there was a whole gamut of different criteria that HMRC presented as what constituted a competent professional, of which experience wasn't one of them. So yeah, the importance on this one, I can see will resonate through the industry.
Absolutely.
So how does the Flame Tree Publishing case differ?
Yes, well, that one went against the appellant.
Yeah.
So what that showed was that the tribunal won't accept a competent professional with a purely commercial background and a high-level view of the project. They need to know and understand the details of the technology. And HMRC have won other cases where there were question marks over the competent professional. Just to say that there's no statutory definition of a competent professional. It's deliberately not defined in the statute. HMRC have got their idea of what that looks like. But basically, following from Get On Board, we can see that if you've got somebody who's got the experience, who is convincing when explaining the project work and the state of the art of the technology, and he's given evidence, if that comes up against the HMRC tactic of just saying there's not enough evidence, etc., without actually giving a specific challenge to what's being said about the technology, then they'll come a cropper at tribunal. And now that's actually happened, and the tribunals found in favour of Get On Board. We know that if you've got that CP who can be articulate, they can convince that tribunal. Doesn't matter if they don't have qualifications. Obviously, the CP is something that's crucial. When you go back to the definitions in the guidelines, a lot of them come down to the judgment of a competent professional. It's important to have that person in place.
It's interesting, isn't it? Because I'm sure there must be competent professionals who've got the qualification who are not particularly articulate. So
yes,
maybe
it
doesn't get to that point, but there you are. I suppose they've got to draw the line somewhere, haven't they?
Brilliant, excellent, yes. So, I mean, these cases came thick and fast, and all gave us some certainty, or at least a direction in which the courts were thinking. The other one I want to touch base on is penalties and burden of proof.
Okay.
So for us, penalties have been talked about for a long time. We've not seen any at Ad Valorem, and I'm not sure on the broader industry whether we've seen penalties distributed. But H&H contract scaffolding was one case where penalties were sort of the key issue of that case. Could you give us explain that tribunal and about what the burden of proof and carelessness actually is? What are HMRC? What are the courts looking for?
Yeah, because I think a lot of companies are nervous about being penalised, even when they've done their very best.
Okay. Oh, absolutely. I think the H&H contract scaffolding case, that showed that when they're seeking to charge penalties, the burden of proof to show that carelessness was present is on HMRC. So it's up to HMRC to show that the company was careless in putting its claim together. And in this case, the tribunal found in favour of the company. It said that just because somebody claiming R&D tax relief is found by HMRC not to qualify, it doesn't automatically follow that they've been careless and should pay a penalty. And in this case, the tribunal found that the company had taken reasonable care and it avoided an inaccuracy penalty. But just to go back to what you were saying, Nikki, about a lot of people being nervous about being penalised, this has become a standard thing in a lot of inquiry cases, that HMRC will threaten penalties quite early in the process. But to consider penalties, HMRC has to show that two conditions are met, that there's an inaccuracy which has tax consequences, and that this was either careless or deliberate. And recent experience has shown, obviously, that HMRC are quite capable of issuing a closure notice in an inquiry case where they've failed to show that there was an inaccuracy at all, and the company would go on to challenge that closure notice. And this could be because the caseworker's understanding of what constitutes an advance may be at odds with the DCIT guidelines, for instance, which explain what is R&D for tax purposes. They've got the force of law, so if you think that the caseworker hasn't used those properly, you've got the right to challenge that. So, it's always going to be something that is up to the advisor, really, to guide a company as to whether HMRC should be challenged on these things. And it might be that you're just going to be explaining how the advance does meet the guidelines, explaining what the law says, and making it clear that, in your view, HMRC hasn't shown that there was any inaccuracy. But if a mistake is made, and it does happen, despite taking reasonable care, then HMRC's own compliance handbook makes it clear that no penalty will be due if you've taken reasonable care.
I think it's one of those things as a business owner, isn't it, that you get a letter saying, penalties and all these things. It feels very aggressive and quite threatening, doesn't it?
It does. But, I mean, in that compliance handbook, there's some examples of when a penalty would not be due. One of those situations is where you've got a reasonably arguable view of situations that is subsequently not upheld. So, the inquiry process may result in HMRC saying, we don't think this qualifies. But as long as you've put forward a reasonable argument on the basis of the law, that a project meets the guidelines, then HMRC can't charge a penalty just because it disagrees with you.
That's the big message, isn't it? That it's HMRC have got to prove it.
I think so, and as well, and I think there's an onus, it's pushing an onus very much on the applicants to do proper due diligence on the advisors they're using. And certainly if that is an accountancy or professional services company, you're looking at a company that adheres to PCRT. I think that's a really important thing that you need to focus on. I think you need to be very mindful of, there's not so much these days, but there were an awful lot of what you would sort of perhaps carelessly call ambulance chasers. There were people that were putting in claims that clearly were not eligible. Do you
just want to say what PCRT
means?
Of
course.
For those
PCRT. So PCRT is a guideline that all regulated professional services adhere to, and it's basically trying to think of the word. It's basically a statement that you're in a position to be able to be a professionally competent person in relation to tax, that particular aspect of tax. So typical things you'd be looking for, if you're doing due diligence on a provider, obviously history, staff, you'd be looking at whether there is a dedicated department. I think that's really important. And I think particularly with the way inquiries have gone as well, you'd be looking to see what technologists that provider is using. So I think you do need to do due diligence in that space. I think that's also an important thing that you need to be able to demonstrate to HMRC, that even if the provider, that you've done everything that is possible in order to ensure that the provider you're using is suitably competent to be able to work with you. So I think that is quite an important thing. It's getting easier now because obviously a lot of the boutiques are closing down as the landscape has changed.
Is it putting people off doing their own claims, do you think?
Well, I think it's obviously a tax specialist area. So to put a claim together in a robust, compliant way, it means understanding the DSIT guidelines and the legislation surrounding R&D tax credits, which is a constantly shifting environment as tribunal decisions influence how something is viewed. HMRC may be updating its guidance, for instance, on particular issues as it finds tribunals disagree with it. So there's always a lot of change, and obviously we're now moving into the new merged scheme, which has its own legislation and its own guidelines to look at. So there's a lot happening here, and I think companies that are trying to do this themselves may find that they're unaware of new regulations, for instance, the requirement to pre-notify a claim in some cases, the requirement to submit an additional information form. They may not be aware of the detail of the categories of qualifying expenditure. They may not know how to present their work in a narrative that shows that the DSIT guidelines are met. It is such a specialist area that I feel that having an advisor who has a dedicated team focused on this, who can keep abreast of all of the changes and the requirements, I think that's really essential.
So, I mean, I think one of the big things lately was the subcontracting and
subsidy and
Subsidy,
reversal
yeah.
policy
Reversal.
that's gone through. So yeah, again, another big one. So Collins Construction, Stage 1 Creative Services. These were big cases. Why were they so big? Why are they so important to the R&D sector?
Well, they have had an impact on how HMRC is going to approach to contentious questions. When are R&D activities considered to be subcontracted to a company, and when are they subsidised? And this ties in with particular legislation for the SME relief scheme. So I'm a former HMRC inspector. I spent many years working on a specialist unit for R&D tax credits within HMRC. And once upon a time, there was fairly broad agreement between HMRC and the tax advisory profession about when these exclusions to SME relief applied. And there wasn't a lot of inquiry work focused on this area. HMRC had published guidance in the CURD manual about these things, which was fairly uncontroversial at the time. But a few years ago, HMRC started taking a much harder line on these issues than it ever had before, and it went to tribunal on a subsidy argument in the case called Quinn London Limited, and it lost that case, but it refused to accept the tribunal's view, and it changed its CURD manual guidance from that fairly uncontroversial point to its new hardline point to support its own position, despite what the tribunal had said. And basically this new guidance, it conflated two separate sections of the legislation to say that if any payment was received under a broad contract to supply a product or a service, this meant R&D that had to be carried out to deliver that contract was automatically both subcontracted and subsidised, and the company doing the R&D couldn't claim SME relief. So HMRC thought this applied even if the R&D wasn't even mentioned in the contract, even if the customer had no interest in whether R&D was being carried out or how it was being done. They thought it applied even if the contractor doing the R&D kept the intellectual property from that development and had complete freedom in how it would do that R&D work. Even if the R&D work put it in a loss position because it couldn't do anything about that under the original contract, then so this new guidance in the CURD resulted in a lot of claims being refused, and the Collins and Stage 1 cases went into both of these issues, subsidies and subcontracting. In both cases, the judge found in favour of the appellant, conclusively rejected HMRC's point of view. And now, because HMRC have lost those two cases, on top of the loss in Quinn earlier, it's been forced to accept that the tribunal is never going to agree with their hardline position on these 2 points. So it has now updated its CURD guidelines, guidance again to reflect what it thinks the tribunal decisions mean.
It's a shame, isn't it, for the ones that have got caught that probably would have, that just haven't done claims because of that element of the contracts.
Yes, it is a shame, and it's notable that HMRC still don't believe that this shows they were clearly in error.
It's unbelievable, isn't it?
I find that quite hard to see from what was said at the tribunals, to be honest. But what they're saying is that, well, there have been circumstances in the past where HMRC did accept that it had made a mistake, and it put some special provisions in place to allow companies to claim relief that they previously hadn't, because of guidance being wrong. They're saying this is not that situation. So companies that tried to obey its hardline guidance and either made claims under the less generous RDEX scheme or didn't claim at all, those companies are, if they're out of time to amend their returns, are unfortunately not going to get that relief. No provisions are going to be put in place.
In the face of innovation and UK growth policy, really, doesn't it? You know, it's to say no, and then you look at all the projects that have been shelved or could have got relief, which would have accelerated that. It's very, very disappointing.
So would you say that those businesses that claimed in the past should revisit now, should not be scared to revisit
Absolutely,
those claims?
Yes. So, you know, looking at the new guidance, it's not exactly just a return to the old status quo before it went hardline. Although HMRC have been forced to accept that those provisions in the legislation about subsidy and subcontracting, two separate parts of legislation, and they have to be treated independently. They now accept that. And the new guidance does suggest a more balanced, fact-based approach. But one thing that's been noticed is that HMRC puts a strong emphasis on the idea that if a customer is simply aware that R&D might be needed, then the work is subcontracted. And that's not what the judges said at tribunal. And R&D tax advisors should look very carefully at that new guidance and see if they agree that the new CURD guidance does reflect those tribunal decisions. The CURD manual is HMRC's view. It's not the law in itself, except where it replicates bits from statute and legislation. And as we've seen, they sometimes do get it wrong. So even after those 3 conclusive tribunal hearings, HMRC hasn't accepted that its interpretation was clearly
interesting,
wrong.
Isn't it?
It's frustrating.
It's very, very frustrating.
Bit about banging your head against the proverbial wall, isn't it, really?
So I guess, to be fair, we probably should talk about cases that they won. Just to give a balanced view on this.
This will be a short section.
So Tills Plus is a case where the claim was rejected.
And does this come down to poor documentation, or more about how the company and subcontractor weren't on the same page, weren't aligned?
Well, yes. I mean, this one, as you say, went against the appellant, and the first tier tribunal denied quite a substantial tax credit claim. So it was all centred around 2 issues. Whether the claimant had made correct payments to its subcontractor and whether the work was qualifying R&D. But the case itself was very, very messy. The appellant claimed to be under the impression that only that issue about the subcontractor payments was at issue, and HMRC said, no, there's this fundamental question as to whether it's qualifying at all. So the appellant brought on new counsel at a very late stage, who basically had 2 days to submit some sort of skeleton argument, I think, before the hearing. So the tribunal felt that the payments to the subby were handled correctly, but they found that the activities didn't qualify as R&D. And this was because the descriptions of the work were inconsistent. There was a lack of documentary evidence to support the fact that an advance was being sought or technological uncertainty was faced. So, yeah.
Why do you think it got that far then? To tribunal stage?
It's interesting because when HMRC comes to the end of its inquiry and issues a closure notice, it's open to the taxpayer to appeal at that point. They can ask for a statutory independent review, and that then goes to a separate team sitting within HMRC legal group to take a look at it again with a fresh pair of eyes and see if the decision is actually made in accordance with the law of the case. So that presumably could have happened here. I'm not sure if it did or if it didn't, to be honest, but there's then a further stage beyond that. If the independent review upholds HMRC's decision, the taxpayer can still appeal to a tribunal, but it doesn't have to get that far, because in between there is an opportunity to apply for alternative dispute mediation, which is where HMRC and the taxpayer get in a virtual room with a trained mediator to thrash out the issues for a full day. You have to apply for that. It's not automatic that you'll be allowed to do that. And I'm afraid I don't know in this case if that was offered or not.
Interesting.
But
It's an interesting one because, again, that's a knowledge thing, isn't it? I mean, the strategy, you know the different stages. And perhaps somebody that is not you, or a firm or a boutique or whoever that may be, that's not used to handling inquiries. Which many of them wouldn't have done, because in the early days, let's face it,
everyone was claiming they didn't have any inquiries.
Yeah, exactly. It's a process that's really important, because to get to tribunal is, is quite a leap.
Well, the alternative dispute resolution is it's something that can actually happen pre-closure notice. If the taxpayer feels that they've reached some sort of stalemate with HMRC, that they're just not being listened to, perhaps a meeting's been refused, which is very common these days, they can apply for ADR at that stage. It's before it gets to the steps of the tribunal, if you like. So,
and I think from our experience of that, I think ADRs are. I mean, that's a heavy day, isn't it? You need.
It's a full day.
It's a heavy day, so you need support. It can be, can't it? And I think again, I think that's where you need support. From someone like you that's used to dealing with HMRC, really.
Well, I think it's very important to go into those meetings fully prepared, having all of your facts at your fingertips, having been aware of the case history, what's gone on in the correspondence, and just making sure that you can, rebut anything that comes back from HMRC and say, no, that's not the case, and point to why. So, yes.
I think particularly when you've mentioned earlier about competent professionals, and even those with the qualifications may not be particularly eloquent.
Yes,
so
that can happen.
It's almost like you'd want to do, if it was me, I would probably want a bit of a practice run to feel confident. Well, that in a pressure situation that you're actually able to articulate what you know is true, but you just can't articulate it.
Exactly. And I think a lot of technologists are not used to talking about their work. They don't need to. They know it, they do it. So having, that sort of ability to get it out there and explain it is, something that, does have to be thought about. And I think in a lot of cases where we find a technologist is maybe a little bit reluctant to speak, it's just a case of giving them a chance to relax a little bit before such a pressurized environment, and have a chance to chat about the work and explore it. And that would normally happen in a claim compilation process anyway, because there should be detailed discussions with the competent professionals in the process of putting a claim together. So if it's the same advisor, they would have got to know that person and hopefully be able to help them open up.
So the continuity helps, doesn't it? I know we've had situations where the competent professional may have left.
Yes,
because these inquiries are taking so long.
Yes, that can happen.
Yeah.
People move on,
Yeah.
and it does sometimes create difficulties. Sometimes even if they've left, they still have that loyalty to want to come back and help, which is good. But yes, HMRC and the mediator do want and expect to hear from the actual competent professionals.
Do you think documentation now is, for anybody looking to make a claim, like internal documentation, so that if a competent professional were to move on, they've got that properly evidenced and can retain that information if this was to occur?
If at all possible.
Yeah.
Sometimes, obviously, circumstances don't allow that. But
I think we've had an instance, haven't we, where we've been able to find a competent professional to articulate better than we could probably a claim recently. So, as you know, at Ad Valorem, the way we work is our team consists of a financial specialist, an accountant who is also an R&D specialist, and the other half of the team is an experienced technologist and we've got those in various fields. So that person is then able to speak to the CP and have a one-to-one discussion and actually understand what's coming back to them to enable them to write the project narrative. And that's crucial, because if you're going in to speak to somebody who is at the cutting edge of a specialist field, if you don't understand what they're telling you, how can you possibly express that in a detailed technical narrative that's robust and compliant with the guidelines? So it seems to me that various companies who are suggesting that experienced in-house technologist can be somehow bypassed, I am yet to be at all convinced by that.
I think the problem you get as well is a lot of the competent professionals consider what they do to be day to day. So you actually need an external party who really understands what they do to say, well, actually you might think that's normal, but it's not. That's the advancement. Yes, could an ordinary competent person have done? No, they couldn't. It's never been done before. And we've certainly had cases where clients have to get sign-off, particularly where it's in a restricted industry, from a regulated body or higher. And it's the competent professional really ignored that bit, but that key piece of paper indicated that was the advancement.
So in one case, we brought in a technologist as a consultant on a case, and he was a university lecturer in this specialist field of industry. And when he was talking to the competent professionals at the company, the claimant, he brought out the fact that in certain circumstances they had to get a notified body to sign off their solution. And that meant that this work could not be routine, because that would only happen in non-standard, non-routine cases. So that little bit of key knowledge was quite vital.
It's something you wouldn't anybody without that experience wouldn't know about. And it's not the interesting thing. It's a bit of process rather than actually a bit of the nitty-gritty building or development of the innovation. So that was an interesting case. That was a.
So I think we're on to key takeaways from this. What would you say, Suzanne, is your one big key takeaway from the tribunals from 2024?
I think it would be HMRC can be wrong. And if you find yourself in an inquiry with a claim that's been prepared in a robust way using a professional advisor who is a specialist in R&D, don't be afraid to stick to your guns. If you've got a strong, consistent claim, you've got knowledgeable, competent professionals, then it's open to you to challenge HMRC's interpretation. And as we've seen in these tribunal cases, sometimes the tribunal agrees with the appellant.
And what do you think at the moment, business leaders that are in the innovation and R&D space, what should they be doing right now to make sure they're not exposed?
Well, anyone making R&D tax credit claims should seek professional advice from a recognised, reputable advisory firm, someone who specialises in this area. And like I've said, ideally, someone with financial and technology experts who can assist with providing that evidence to HMRC.
It's very much a team, isn't it? It's very much a collaboration between the professional firm and the client and the R&D, the client. Yeah, obviously.
It's obviously a consultative process to get that detail.
And I think we've seen a reduction in the amount of accountants that are now providing the service, because I think it's one of those things that you're either very dedicated in it or you don't do it.
You can't leave it. I know one of the questions that I've seen from HMRC is to the client is very much, are you completely au fait with the R&D regulations? And I think if you've got an accountant or an individual just preparing numbers, they haven't got that more holistic view of actually working with the client, the in-depth knowledge of what R&D is, because it's not black and white. Obviously, it's about interpretation, it's about understanding. So yeah, I think that it is very much now sitting with professional service firms that have focused teams that just do R&D and nothing else. And that can only be a good thing for quality and for the scheme, which I think we all agree is so important to the UK's emergence and growth and development. So that is a good thing. Suzanne, thank you. I think the tribunals are giving us some clarity to a degree, and perhaps forcibly pushing HMRC into a position of certainty to a degree, or certainly taking away some of the grey areas, which is always the great thing about it going to tribunal. It's a pain, it takes a long time, but it does actually help us develop a framework, which is good for all of us. The impact it takes a long time. The impact, once it comes through, is pretty immediate. So that's really good news.
And I think for me, what I've gained from you, Suzanne, I think is that it's not just about tax and accounting and the technical side, it's also about the legal side now as well. So and I think that's exactly why we wanted to set up Lumina, because I think this is about going beyond normal compliance. So
indeed. That's great. Well, thanks for listening to In Focus, Lumina Insights. We'll be back soon with more expert-led episodes across specialist tax and advisory services. Hit subscribe at the bottom of the screen if you've enjoyed the podcast. Thanks very much.